The Federal and Vale Hospital jointly present the Madurai Marathon 2025. This event is co-presented by Walking Shoe Company and powered by PSNA College of Engineering and Technology and Tucker EV Chargers. Run for bone and joint health on Sunday, December 7.
On November 14, the government notified the rules for the Digital Personal Data Protection Act, putting India's first digital privacy law into force. The rules lay out timelines and compliance obligations for entities handling personal data and set the stage for how citizens will exercise their data rights. But as the framework comes into effect, concerns remain about its impact on transparency and the freedom of information. We have with us digital rights activist Nikhil Pahwa, the founder and editor of Medianama, and the co-founder of the Internet Freedom Foundation. So, welcome. And to begin with, I'm just going to ask you what your overall impression of the DPDP rules is, and particularly from a user's perspective.
Thanks. So I think it's good to have at least some rules protecting user rights, even though these are long delayed. And that's probably because the Indian government didn't want a data protection law in the first place. But, at least we have something now. It's also important to remember that this isn't a data protection law, but a digital data protection law. And it covers only digital data and not data stored in physical formats. So, if you're entering a building and you're signing a register with your phone number, email address, or address and all of that information, that is not protected under this law. Only information that's collected about you online is essentially you have some rights regarding. There are some positives first about this law that I think it's important to know. One problem that we've had in the past is that if your data gets breached or, if you've used a website and that website gets hacked and your data gets stolen from there, quite often companies did not inform users that this has happened. Only in case of particularly responsible companies like Zomato, this has happened in the past. There are companies that we know where data has been breached, but they've publicly even denied the breach. Now they will have to necessarily inform the user that there's a data breach and there's a format given for that. Secondly, if any information that a company has about you is incorrect, then you have the right to request correction to your personal data. And this is particularly useful in case of, digital data that's recorded by lending companies, etc., or digital banks if they're ever to come into play. It's because there is sometimes people collect data from multiple sources. There could be incorrect data that might have been entered that you now have the right to get that corrected. Once your data is, once you've finished using a service, there is a provision where, and that purpose for which the data was collected is served, except in some cases like e-commerce and social media, companies have to delete your information if you shut down your account in particular, right? So you have a right to erasure for your personal data, or if you withdraw your consent or the purpose has been served for which the data had been collected. So there are some restrictions on companies. They can't store your data till eternity unless it's required by law for them to retain that data. Then you have a grievance redressal system that will have to come in place with companies, where if you have a privacy concern or a complaint, or even if you want, let's say, an itemized description of what data they are processing of yours, and you want transparency regarding what are they using your data for, they will have to give you a description and an explanation for that. So we have rights against companies. And also, one of the challenges that we see is that when people are using accounts and let's say someone passes away, access to that account, access to that data, no one knows what happens there. There are no norms for that. So you have the right to nominate and you have the right to have a nominee for your data in case, let's say, you pass away or something. So there are some provisions that have been thought through and they've been incorporated in this law and the rules, that is. but not enough. There are some problems there. For example, this data protection law was came into play particularly because of Aadhaar and the potential surveillance risks that would come in. This bill act, and we got the right to privacy judgment against the government of India, because the government went to court saying there's no fundamental right to privacy, and the Supreme Court disagreed with them. Right? It's been about 9 years since that judgment came out. This particular law actually exempts government from accountability, or largely exempts it from, kind of like a surveillance. They have freedom regarding surveillance in the sense that they can take your data from private parties without you even being informed. So there are concerns regarding government's collection of data. There is no exemption for AI companies scraping your personal data from the open web. So, for example, in the US, there was a service called Clearview AI, which was collecting users' personal data for their photographs from social media and using that to build facial recognition. Now, they lost that case. They were fined in the millions of dollars for violating user privacy. In India, we've given a complete exemption to this kind of personal information that we may have made public on social media platforms. So, lack of protection against AI scraping and training is a big problem. Um, we also have a situation where, I don't like this provision. They've sort of left the door open for data localization when the government wants it, and that brings in uncertainty, and for startups in particular. uh, but so there are issues with the bill. It's not that it's perfect. It's not that there are a lot of areas where the government could have been had done better. It's not that they weren't given feedback. But I'm glad that we finally have rules 9 years after the right to privacy judgment came in. It's taken them 9 years of delaying for this to come in.
So you just, since you mentioned that there was feedback, so I wanted to know whether you think that the rules and the act themselves, what was that the process transparent, and was there enough public input taken for that, you think?
So there was a process by which public input was taken, but there was lack of transparency from METI, from the Ministry of Electronics and IT, because typically under their pre-legislative consultation policy, they're supposed to share submissions that are made to them, so that we have an idea of what people are asking them to do. But that didn't happen in case of the rules, and in case of the last bit of the law as well. The government has not disclosed submissions that were made to them. And it's not just this law. In general, there's been a lack of transparency and accountability when rules and laws are being made, where the government is not disclosing information. In case of the broadcast bill, for example, they took submissions last year. And when we filed an RTI for that information, they responded by actually reaching out to people who had submitted, asking if they want to make that information public or not. And that boils down to how the RTI Act is also being diluted over here, where if there's personal data, then the government can, especially regarding bureaucrats and decisions related, government can choose not to give information. So the process hasn't been transparent. In fact, this has gone and reduced transparency that was being provided by the RTI Act, which is why there is opposition to the way this law has worked. Apart from that, I'm a journalist, and from a journalism perspective, people that we are reporting on, by the looks of it, there is no journalism exemption to this. This particularly hampers investigative journalism.
Okay, then I'm going to, you've already touched upon some of the concerning bits in the rules and the act. Now, I think there is a certain rule 23 which allows the government to seek information from what they're calling data fiduciaries on grounds like sovereignty, integrity, or security of the state. And the individual does not need to be informed. So, what would this mean for user privacy and accountability?
So essentially, what Rule 23 does is that the government can seek data from private parties about you, under sovereignty, integrity, and security of the state without informing the user. So you, as a user whose data is being taken from a company by the state, do not have the right to be notified. You don't have the right to object to the data being taken. You don't even have the right to know afterwards whether that data has been taken. You don't know what data has been taken by them, what has been shared by a private company, and you don't have a right to, essentially, you can't challenge misuse of that data. So, effectively, what is happening is that private companies become an extension of surveillance by the state. So if any app that you're using and they're collecting data about you without any oversight, without judicial oversight, without a warrant disclosure, um, the government can take information from private parties. So it's a form of privatization of surveillance where every app you use is effectively surveilling you, and the government has full right to get data about you from that from that service and application. Remember that the right to privacy judgment that we got in 2017 gave us rights against the state. This effectively undoes that, because there's no warrant disclosure required. There's no judicial oversight. There is no independent supervision of demands for this data. So effectively, it's a surveillance provision. The irony is that a privacy law is being used to expand user surveillance.
I also wanted to ask you about Rule 8. You said that it's not like personal data can be stored indefinitely. But
Yeah.
I think Rule 8 says that companies and the government can retain personal data for years, even after it's no longer needed. So, for users, is there a risk here?
So look, this is a tricky provision, right? Because there are laws that, for example, for let's say digital payments or for e-commerce, there are situations in which, or for let's say taxation purposes, there are laws that require companies to collect and store data about you, because laws already enable that. If you stop using a service, that doesn't mean that the company can't hold retain data about you beyond you're not using the service anymore, because they need that data to prove that they've sold you something, right? So I this is a tricky one, because companies for their own legal purposes have to store the data because they're required to do so under law, and you want to get that data deleted. In this case, there is an exemption that if there is a law already in place that requires retention of data, then companies will be required to retain it. It undoes the right to erasure to quite an extent, but that's largely from a transactional purposes, for purpose like, or for example, if you purchase an online insurance and 10 years down the line, they need to still prove that they sold you that insurance, right? So it's this is a tricky one. It does mean that you don't have the right to get anything deleted. You can't just buy something from someone and then ask them to delete all records of your purchase there. Um, but and so it creates a risk for surveillance. But and also when if there's a data breach, that entity will still have retained your data. So it's the right to erasure or right to delete your data is sort of weaker than it appears on paper over here. But I'm a little unsure of whether you need it for compliance purposes already. So it's tricky.
Got it. And what do you have to say about what the rules say for children? Like Rule 10 mandates strict age verification and parental consent. So how do you view this?
Look, I started using the internet when I was 16 years old. I would have been below the age of parental consent. My parents may not have known how to use a computer or give consent. So I understand that there are a large number of people in this country, who are where the children are the primary users of digital technologies, right? And the parents they may not necessarily know how to give consent. So the strict age verification of above 18 for every service that a child uses is deeply problematic. and it would have been a disabling provision where we want children to become more digitally literate. You're effectively forcing them to seek consent, and there's consent fatigue. Parents will also stop paying attention to what they're giving consent to after a while. And effectively, even to read a news website, you would, if a child has an account there, you would need to give parental permission for that account. So it's problematic the way it's been done. Now, the ministry in the rules has tried to override in some shape or form what the law does. The law is problematic. We've given feedback to the government on it repeatedly, uh, and it doesn't, it's still, it's still passed the way it did. But so the ministry in the rules is trying to create some provisions with some specific examples where that law no longer, laws being overturned by the rules. Now, this is legally contestable because the rules cannot do what the law doesn't allow. Um, it also creates a room where, for example, a child can lie about their age, and just because they haven't disclosed they're a child, the platform has no obligation to get parental consent. So, like I think, it overturns the law, so to speak. I don't think this rule is legally valid, but the original law which it overturns is by itself problematic. uh, the government had a very hard task to do over here. They didn't want to reduce agency. So I understand the problem, but they could have passed an amendment to the Data Protection Act to address this, or they need not have notified this particular clause altogether. But we have what we have. It's a mess of their own creation because we gave them enough feedback about it.
All right. So now I wanted to ask you about the Data Protection Board itself. So, from what we understand, right now the government fully controls the appointments and the operation of the DPB, but it is meant to protect user rights. So, from a user's point of view, can we see this being an independent body?
I think the board has many problems, and the fact that we have a data protection board instead of a data protection authority is itself a problem. Most countries, most developed countries, they're even developing countries across the world, have data protection authorities which have the ability and the power to make rules. For example, let's say for children and their usage of the internet, for algorithmic accountability, and they have independent powers, so to speak, uh, including on acting against government bodies and the usage of data. So, as an example, I think a few years ago we spoke with the chairman of the Data Protection Authority of the Philippines, and he told us that when they started, their first action was to hold to account the Election Commission of Philippines because they had published personal data of users on the internet. uh, and so they actually held the data protection agency, so the election commission of Philippines, to account for privacy violation. India's data protection law basically makes the data protection board kind of like a lame duck. uh, you know, you really can't. They're actually disempowering users in this case, because the board is going to be appointed entirely by the government. It would they've I think they've expanded the rules to say that a government official can also be appointed to the board, uh, which is from another government body. There are only four members. We know of instances, for example, in Germany, uh, each state has its own regional data protection authority. For a country as small as Germany, with as few people as Germany, in India, you have four people handling the privacy concerns of 1.4 billion. That is utterly ridiculous, right? So, also the way they've done this is that if your privacy gets violated, you have to go to the data protection board. You can't go to a court straight away. And then, so you have to go to the board, then to the appellate. So the process here is long drawn. It's punishing, because of the fact you have to go through multiple levels before you get uh, so it's built to not provide justice to people, the way I look at it. It's built not to look into concerns of privacy independently. I think the biggest task for the board is going to be to establish its own legitimacy and its own credibility in order to be taken seriously. Um, and I think that's where this law, not because a law is as good as as its enforcement, and if your board is the only one that's going to be enforcing it, uh, then and it is largely restricted in what it can do, and it restricts the rights of the users, then this is, as we expected, a data protection law for the sake of having a data protection law.
So I just have to ask you if there's anything else that kind of stands out for you or you think needs to be, looked at when it comes to the DPDP rules.
Um, I think what's particularly challenging for me with the rules is how it seems to be. It's taken so long to put together the law to come into force, and there are another 18 months before it comes up. Is that it's? I don't think there are provisions that protect us from privacy violations, especially related to AI. The fact that scraping seems to be allowed, where your personal data can be collected from across the web because if it's publicly available and used and processed by AI services, is something that is problematic. We don't If, let's say, I want the right to erasure by an AI company, if I've shared my personal data, there are people who upload their medical reports onto chatbots right now to get feedback. If they want their personal data to be deleted, how will that apply to AI? So there are, it's taken the government so long to get a data protection act that technology by itself has moved on. Uh, the other aspect that I find concerning is this entire consent manager framework, because it reduces friction for data collection. It has no business being in a data protection act, to my mind, because what we are seeing with account aggregators, which are types of consent managers currently in place, uh, they are used to collect your personal information across financial services to be given to other financial services, right? So, for example, there was one account aggregator company that went out and said that on the basis of the number of rupees 19 transactions that a user is doing, they're able to assess whether that person is smoking or not, and they'll give that information to a health insurance company. So, there are inferences that are being drawn without your knowledge, without your consent, from information that is by no means correlated with what you're doing. But you don't, and that entire framework of data collection and analysis is being made easier through the Data Protection Act. How is that privacy protecting is something I don't understand. So I think there are challenges with this act, and I don't expect an easy resolution of these issues.
All right. Thank you so much.
The Federal and Male Hospital jointly present the Madurai Marathon 2025. This event is co-presented by Walking Shoe Company, powered by PSNA College of Engineering and Technology and Tucker EV Chargers. Run for bone and joint health on Sunday, December 7. Entry is free. All are welcome.